Morning, all of you. Now we are going to talk about the Christians of scheduled caste origin. The Constitution, paragraph 3, Christians of scheduled caste origin to avail the scheduled caste status par with Hindus, Sikhs and Buddhists of scheduled caste origin. This order is otherwise called as Constitution Order 19. It was promulgated by the then President on 10th of August 1950. Main reason for the denial of scheduled caste status to Christians of scheduled caste origin is that Christianity doesn't recognize untouchability practice. Social exclusion is different from religious perception. For example, in Western countries, Europe, America, though white and African American black Christians were following Christianity, apartheid was prevailing there, racism was prevailing there. So, social exclusion is different from the religious perception. Caste discrimination, it is not only there inside the church, it is prevailing everywhere. It is prevailing in the society. It is prevailing in the fields. It is prevailing in the public places. So caste discrimination is different from the religious values. On what basis the scheduled caste status is given to the people? As per the mandate modality of the Government of India, year 2000 and 1999, the community should be socially educationally backward, arising out of the traditional practice of untouchability. Then only that particular community could be eligible to avail the scheduled caste status. Here, Christians of scheduled caste origin are also socially educationally backward. They are affected by the traditional practice of untouchability, which is prevailing among the Christians and among the wider society. In Susi versus Union of India case, the petitioner had challenged the Constitution Scheduled Caste Order 1950 paragraph 3's religious ban, which prevents Christians of scheduled caste origin to avail the scheduled caste status. Finally, the court said to avail the scheduled caste status, the petitioner should have proved his socio-educational backwardness arising out of the traditional practice of untouchability with cogent, authoritative and detailed evidences. What are all the cogent, authoritative, detailed evidences which prove the backwardness of Christians of scheduled caste origin par with Hindus, Sikhs and Buddhists of SC origin? The following reports were made by the Government of India as stakeholder. The first Backward Class Commission report, year 1953-1955, it talks about the poorest plight of the Christians of scheduled caste origin. This commission was headed by Kaka Kalelkar. In the year 1969, Parliamentary Committee on Untouchability headed by the then MP L. L. Burmal, it had recommended to Government of India for extending the scheduled caste status to Christians of SC origin because they are victimized in the rural society because of the caste discrimination. Then in the year 1981, another commission, that was second backward class commission, it had recommended to Government of India for granting scheduled caste status to Christians of scheduled caste origin. In the year 1983, another commission was formed by the Government of India, that was High Power Committee on Minorities, Gopal Singh. This commission had strongly recommended to Government of India for granting scheduled caste status to Christians of scheduled caste origin. Based on this commission's recommendation, in the year 1996, on 11th of March, Government of India had proposed a bill in the floor of Parliament for amending the Constitution under Article 368, Subdivision 1, for extending the scheduled caste status to Christians of scheduled caste origin. Because of some administrative reason, this bill was not discussed and accepted in the floor of Parliament. Again, the government had sent it for the consideration of the then President for getting its approval as ordinance. It was not accepted by the then President. In the year 2001, a National Committee on the Working of the Review of the Constitution headed by Honorable Venkatachalaya, it had recommended to Government of India for granting scheduled caste status to protect these people when they are victimized in the society because of the caste discrimination. In the year 2006, another High Power Committee on Minorities was formed by the Government of India. Honorable Justice Sachar. This committee had also recommended for granting scheduled caste status to these people. In the year 2007, National Commission for Minorities, it did an exclusive scientific study on the plight of Christians of scheduled caste origin by Delhi University professor Dr. Satish Deshpande. That commission's report, it very categorically said it is justified to grant scheduled caste status to Christians of SC origin immediately. So, as you all know very well, in the year 2007, National Commission for Religious and Linguistic Minorities report, it had been handed over to the then Prime Minister. Report came into public domain in the year 2009. It had recommended to Government of India for delinking religion for the considered scheduled caste. It said and urged the government to make scheduled caste net as religion neutral. As you all know very well, a case is pending in the Supreme Court of India where the National Commission for Minorities and the National Commission for Scheduled Caste second and third respondent. National Commission for Minorities, it had filed a positive response in the Supreme Court for extending the scheduled caste status to these people based on its many recommendations to government and the study which had been done by Professor Satish Deshpande. National Commission for Scheduled Castes are also, this commission has also brought its view before the Supreme Court. As per its decision, year 2007, it said Dalit Christians of SC origin may be given the SC status without affecting the existing 15% quota. In the year 2010, the National Commission for Scheduled Castes had fully endorsed the recommendation of National Commission for Religious and Linguistic Minorities by reiterating its earlier year recommendation, that is 2007 recommendation. In the year 2011, the same commission, it said, after denoting about 2007 recommendation and 2010 recommendation, it categorically said, in religious environment, if the scheduled caste origin are facing the traditional practice of untouchability, they may be extended the SC status. This is the position of the National Commission for Scheduled Caste. Now, we are in a position to prove the socio-educational, economic and cultural backwardness of Christians of Scheduled Caste origin, par with Hindus, Sikhs and Buddhists of SC arising out of the traditional practice of untouchability with cogent, authoritative, detailed evidences, which I said earlier. In the year 1956, based on the first Backward Class Commission's recommendation, 6 of Scheduled Caste origin, they had been given the SC status. The same first Backward Class Commission, headed by Kaka Kalelkar, it had very clearly explained the poorest plight of the Christians of SC origin. But the Scheduled Caste status was not extended to these people. In the year 1983, the High Power Committee on Minorities, headed by Singh, it had recommended for granting Scheduled Caste status to Buddhist and Christians of Scheduled Caste origin. In the year 1990, Buddhists of Scheduled Caste origin, they had been extended the SC status, but Christians of SC origin had been neglected. Though the government, central government had introduced a bill in the floor of parliament, it was not materialized. Though Sikhism and Buddhism, both the religions recognize caste discrimination, they had been extended the SC status. In the year 1956, 6 of SC origin, they had been extended the Scheduled Caste status. In the year 1990, Buddhists of SC origin, they had been extended the SC status. But both the religions do not recognize caste discrimination. When we ask why, what is the reason behind it, people say both the religions are offshoot of Hinduism. If both the religions are offshoot of Hinduism, in the year 1950 itself, they had been extended the SC status. Why did they do separate amendment? If both the religions are offshoot of Hinduism, on 10th of August 1950 itself, both the religions, Sikhs and Buddhism might have been added in the presidential order, that is Constitution Schedule Caste order, which was not done. As per National Commission for Minorities Act, Sikhism and Buddhism are separate religions. Here, once again, I want to emphasize the point: social exclusion is different from the religious perception. Whenever we demand the scheduled caste status, people say Hinduism does only recognize untouchability and the related caste discrimination. Hinduism is a good religion, it is the way of life. It never motivates untouchability. As per Article 17, untouchability is a crime. Whomsoever are motivating untouchability should be prosecuted. Here, how far these people are discriminated, that is the important factor. For example, Christians of scheduled caste origin are treated as untouchables, treated with caste mind in the Christian society and in the wider society. As said by me earlier, social exclusion is different from the religious perception. By considering all these factors, the Constitution Scheduled Caste Order 1950 paragraph 3's religious ban should be struck down. Constitution Scheduled Caste Order 1950's amended as per Article 368 Subdivision 1 for the extension of scheduled caste status to these people. This ban is against Article 14, which talks about equality, Article 15.1, which talks about non-discrimination, Article 16.1, which talks about non-discrimination in employment, Article 25, which talks about religious freedom, Article 17, which prevents untouchability and its related practice. If it is done, the Christians of SC origin would be eligible to get the privilege in education as per Article 15.4, Article 16.4, and they would be able to contest in the reserve constituencies, par with our Hindu, Sikh and Buddhist of SC origin people, as per Article 330 and as per Article 334. So this paragraph 3 religious ban is unconstitutional. Thank you very much.